Good morning, members. It's the appointed time. We have a quorum. I now call the meeting to order. This is the panel on administration of justice and legal services. There are two items on the agenda. First, policy briefing by the Department of Justice and the Administration Wing under the Chief Secretary for Administration's Office as well as the Judiciary. We now invite the officials to join us. The policy address was delivered last year in September.
政府方
The administration would like to brief members on the policy address. That's why we will allow more time at this meeting for officials to brief members. We welcome the Secretary for Justice and his deputy, as well as the officials from the administration wing of the Chief Secretary's office. We also have officials joining us from the Judiciary and also the Legal Aid Department. Please have a seat. Members who would like to speak, please press the Request to Speak button. So there will be time for you to raise questions or speak. I need to get a sense of how many wish to speak, and then I will enforce a time limit. Secretary for Justice, whenever you're ready, please brief us. The paper is LC paper number CB bracket 325/2026 bracket 01. Mr. Lam will also tell us about the International Organization Privileges and Immunities International Organization for Mediation Order Legal Notice number 217 of 2025. Whenever you're ready, Secretary for Justice. Good morning, Madam Chair. We all know the members are ready, but I have to say this. On behalf of the Department of Justice, I'm grateful to members for joining this, and I welcome all of you. Today, I want to tell members about a few areas of work. First, I want to discuss my thoughts on the work of the DOJ, and as the Madam Chair said, I will also explain how the order about IOMED works. And I will also go through some items that the DOJ will propose for discussion this year. Now, on my views on the DOJ's work and how we interact with this panel, the DOJ will remain proactive in staying in touch with members of this panel. We will establish a good working relationship. We will brief members on our work in a timely way. We will consult members of the panel so that we foster a candid and positive interaction. For the DOJ's other areas of work, such as the bills drafted, we also welcome members' views on that. We will have formal meetings. Members are also welcome to raise issues of concern anytime. I also hope that members can understand that some issues may have to do with the legal system, but the work may fall outside the DOJ's work, such as issues related to the judiciary and also follow-up actions related to the report released by the Law Reform Commission. First, about the International Organization for Mediation. Now we have the International Order Privileges and Immunities International Organization for Mediation Order. Now, some context first. On the 30th of May last year, the Convention on Establishing IOMED was signed in Hong Kong. There was a ceremony. We got countries from Asia, Africa, and Latin America. More than 30 countries signed that convention. More than 50 countries, and also people from the United Nations. And also roughly 20 international bodies sent their people to witness the signing ceremony. Under that convention, with the ratification of 3 member states, this treaty took effect on August 29th last year. On the same day, this convention started applying to China, and that includes Hong Kong, as our country is one of those 3 member states ratifying the treaty. So we will first discuss the legal status of IOMED, and then there is also something on the immunities on the personnel. The Chief Executive in Council acted under Section 3 under Cap 558 to make this order. The order was gazetted on November 28th last year. On the 14th of January this year, this order was laid on the table of this Legislative Council. Now, some further details. Rule 1 of this order says that this piece of subsidiary legislation is deemed to have come into operation on August 29th last year. So that means this order is deemed to take effect starting from the day on which the convention applied to the PRC, including Hong Kong. Now, this may give the impression of a retrospective effect. The convention was signed last year in August. There's a national law. Under that law, Article 27 gives effect to the application of that convention to Hong Kong. And then Article 18 of the Basic Law says that any national law that applies to Hong Kong is also deemed to be promulgated in Hong Kong. That's why this convention is legally binding in Hong Kong. Whereas Hong Kong is a common law jurisdiction. And I'm sure members are well aware that under common law principles, when international conventions apply to Hong Kong, those conventions do not form part of Hong Kong's laws automatically. Local legislation is needed to give effect to such conventions. That's why we need such local legislation expressly granting privileges and immunities. That's the clearest and most well-defined way to proceed with the work. Granting privileges and immunities falls under foreign affairs, and that within the prerogatives of the central government. Now, the convention was signed on August 29th, so we went ahead to make the order after August 29th. We had to consult the central government. With the central government approval, we then sought the approval of the Chief Executive in Council under Cap 558 and then submitted the order. And we are also aware of the new term of Legislative Council coming into effect. That's why on the second day, January the 2nd, we tabled the legal instrument at the Legislative Council. This order reflects the legal position starting from August 29th. And we have to be consistent with the requirements under Cap 558. That's why this order is deemed to have come into effect on August 29th. I hope this explanation can show members the legal context and the commencement of the provisions of this order. And I hope I have also taken members through the preparations for this order to take effect. And I also want to discuss how the IOMED relates to the SCR government. The order I have mentioned is an entity with its separate legal existence. IOMED is subject to its own regulations and rules. IOMED is not set up by any single country. The institution does not form part of Hong Kong's or China's authorities. IOMED has its own executive authorities. It has a Secretary General. It has a Secretariat. The first Secretary General is Ms. Teresa Chang. The officials of IOMED will run and manage IOMED under IOMED's own rules. That's why the HKSCR government will not be directly involved in IOMED's operation. Having said that, I want to point out that our government will fully support IOMED's work. The government is now in talks with IOMED about sending DOJ officers to IOMED on secondment. This is the same practice as that of seconding our people to other international bodies. And we're trying to set up an appointment with IOMED Secretary General Ms. Teresa Chang to find out about their work plans. That will help us find out how we can better support the operation of IOMED in its early days. Now, I want to discuss something that is like what you see on TV. So you can take what I'm going to say as a trailer. Last year, the policy address proposed certain measures. Now I want to give you an overview of what to expect in a more systematic way. And we will be consulting members on the work. Our overall strategy is straightforward. We want to uphold the rule of law in Hong Kong. We want to strengthen and enhance Hong Kong's role as a legal and dispute resolution services hub. And that will lay a foundation for our prosperity and stability. We will fully cooperate with our country's reform opening and development so that we can better align with the 15th five-year plan, which is due for release soon. Before the meeting today, we prepared PowerPoint slides. You will find 8 areas in the slides. These are the highlights of our work. The different areas are interrelated. All 8 areas are important. So we're not saying that one task is more important than the other. Where resources permit, we want to proceed with all 8 areas in tandem. We also welcome members' comments on our work so that we can adjust and enhance our measures. Now, I don't want to take up too much time for members. I know members are keen to hear from the Judiciary and the Legal Aid Department. I also want to allow more time for questions. I will not go through the slides in detail. I will simply highlight the key areas. You will find the 8 points on the first few slides. First, building the new legal hub building. So that's the hardware. You need the hardware before you can take forward the work. So we have identified the site. Right next to IOMED's headquarters, there's a site. That site will be home to the future International Legal Service Building. We're now proceeding with the advanced work. We have to go through steps before we can put a building there. We're now at the stage of initial research. We have to find out how much space we need. We have to consider the building height restrictions, etc. And we're now in talks with other policy bureaus with this research phase. We do have some concrete plans in mind. One key function of this building will be to give more space for our International Legal Talent Academy. We want more training space. We need better auditoriums and also conference rooms. Those are areas where we face challenges. Hong Kong to become a center for mediation and arbitration, and we know stakeholders need such venues. So where feasible, we will create more space for mediation and arbitration.
Many international and local legal organizations need their space as well. We will try our very best to meet their needs. We need to strike a balance between development and planning. What matters are resources. We will give an account to members later on when the time is ripe. I urge members to understand the long-term importance of this matter with resources taken into account. We need to make good use of resources, but we also need resources to implement our policies. This is on point number 1. Point number 2, continual attraction of international organizations to set up in Hong Kong. Just now I touched upon IOMED. For the legal services building, we are in talks with the Secretariat of the Hong Kong International Legal Talent Training Academy. When there is sufficient space, we will pave way for the further development of the academy. We want to have flexible arrangements. But in addition to IOMED, we are striving for different international organizations to set up operations in Hong Kong. And we are working on UNIDRA. We want it to be established in Hong Kong. We have HCCH, UNIDRA, as well as UNCITRAL. Last December, we saw the establishment of the organization. For the very first time, it set up a headquarters or an office elsewhere, that is in Hong Kong. We want to see it commissioning by the end of this year. And we will also attract other international organizations to set up operations in Hong Kong. Next, on the capacity building of legal talent. Many members helped with the work of the Hong Kong International Legal Talent Training Academy. I'm grateful to members. We have seen encouraging results. As I said, we don't have a lot of manpower, but last year we held a lot of activities working with different organizations such as legal organizations, mainland units, as well as local groups. We held a wide array of activities last year. We want to work more on this front. There are 3 main focuses. One, we need to tie in with the policy to enhance the foreign legal affairs capacity building of legal talent. We invited judges who are well versed in company law to come to Hong Kong. We also provide support to local lawyers. We want to enhance their capacity building. Last year, we held activities to introduce the situations in mainland China. It wasn't just textbook knowledge. We told them the real circumstances in the Chinese mainland. We also deepened Belt and Road cooperation and developed multi-jurisdictional Asia-Pacific legal talent. We share our experience with learners, but at the same time, it is a good opportunity for us to tell the good stories of Hong Kong. Why is our reputation as the international legal hub around the world, a well-earned reputation. We want to give local lawyers a better picture of the legal landscape in the Chinese mainland as well as in Hong Kong. We want them to have a better picture of the situation in the Chinese mainland. More importantly, we want them to expand their social circles, and this will pave the way for their future development. Regarding the promotion of our legal services as a world-class platform for going global, where time allows, together with my deputy and my other colleagues, we visited different countries, the Middle East, Europe, Southeast Asia, mainland cities. We went to all these places, but I'm not going into greater details. We'll continue with our efforts in this regard. This year, my deputy will make a visit to Indonesia. Probably in the middle of this year, I will go to Kazakhstan, that is Central Asia. Apart from visits, we have made breakthroughs in our system. We have set up the Hong Kong Professional Services Go Global platform, and we have published the Go Global success stories. We want to give you real-life examples, give you a real concept. What kind of role can we play? How can we help mainland enterprises to go global? Moving forward, we'll continue to make visits to other countries and places. We want to enhance the function of the Go Global platform. On point number 5, we foster legal cooperation and interface with the GBA and other parts of the Chinese mainland. First of all, last year, allowing Hong Kong invested enterprises to adopt law and to choose for arbitration to be seated in Hong Kong were expanded last year. We want to encourage even more enterprises to choose to adopt Hong Kong law and arbitration to be seated in Hong Kong. For those meeting the definition of Hong Kong invested enterprises, we want them to choose Hong Kong law and Hong Kong arbitration. Arbitration, mediation, we have a mechanism with the GBA, and we have a panel of GBA arbitrators and mediators. All these are ready. We also have the GBA mediator panel, and the key is how to make good use of these resources. Next year, we want to set up the GBA Legal Information Platform so that more people will know more about the panel of arbitrators, mediators, and so on. The development of GBA matters. Last year in October, during the Hong Kong Legal Week, we set up the GBA Lawyers Organization. Members included lawyers who have the practicing certificates in both the GBA and in Hong Kong. This year marked the end of the 3-year pilot scheme. I will strive for the regularization of the GBA lawyer scheme. Among lawyers, there needs to be good interaction. Lawyers need to share their experience with their peers. For instance, what kind of challenges do they come across? How can we better help them? We want to make good use of the organization to take forward our work. We want to implement this policy in a more effective manner. I'm not going into detail about matters with the Chinese mainland, but all in all, we will make as many trips as possible. For example, last year we went to Tibet and Xi'an. And we will also go to Shanghai and Hangzhou for exchange. Point number 6, driving growth of Hong Kong's legal and dispute resolution services, DRS. There are two main fronts. 1, mediation, and 2, arbitration. Both of them require a good legal framework. They need to move with the times in order to meet the needs of users. So be it arbitration or arbitration, we have already established working groups. We have brought together experts from the two places. We want to tap the pulse of stakeholders and users in order to improve the mediation system and regulations and laws on arbitration. Legislative amendments will be involved, of course. So in the years to come, we will come back to the Council to have a detailed discussion with members. In addition, we have sports dispute resolution as well. When it comes to mediation, it's not just about high-level mediation. We shouldn't forget that by mediation, we want to help the public to resolve their day-to-day disputes. Last year, we saw the success of the pilot scheme on community mediation. This year, we'll together with the EEB and the FEHD organize more training sessions on handling building water leakage disputes. We will enhance the knowledge and confidence of frontline officers. That's why we attach importance to high-level mediation, but we also attach importance to community mediation. Next, on the promotion of law tech and study on law relating to artificial intelligence, that is AI, the Deputy Secretary for Justice led the consultation group on law tech development. We held roundtable meetings, and we organized the inaugural Hong Kong Law Tech Fest in December 2025 during the Hong Kong Legal Week. We wanted to encourage the legal sector to use AI and law tech. Where possible and where appropriate, we want to help the industry to get started with using law tech. According to the policy address, we are going to establish an interdepartmental working group to coordinate with other bureaus to review the legislation needed to complement the wider application of AI. It's come to my attention that in other panel meetings of the Council, related matters were brought up. For example, the use of AI, deepfake. Do we need to move with the times and enact legislation in relation to the application of AI and to combat deepfake? The policy is actually straightforward. We need to forge an objective environment to align with the expectations of our nation. We also need to guard against misuse and abuse. We need to ensure AI will be developed on a level playing field. We also need to make sure the interests and rights of the public will not be compromised. We need to foster a healthy, fair and just ecosystem.
法治教育
The last point, also top of mind for me, and that is rule of law education. I'm grateful to many members present who took an active part in the effort over the past few years. The efforts have produced good results, so we will keep up the effort. So we will have a ceremony to recognize the good work of the people who got involved. So we need people to share the effort. So we will be awarding the rule of law education ambassadors and need to keep up the effort on this. This is crucial to our effort to strengthen rule of law education. Last year, we had the first edition of the Role Drama Day that was well received, so we will keep that up. And we will also update members on the work. I have taken up roughly 30 minutes, so I will stop here. So this is just the trailer. As we go along, I will go into deeper discussions with members in the future. I thank the Secretary for Justice for the detailed presentation. So this is like a trailer of things to come. I want to declare an interest. I used to be in the same law school with the Secretary for Justice. We take forward our work on the basis of mutual trust and respect. Now, our terms of reference goes like this. We uphold the independence of the judiciary and the rule of law, and then we discuss matters related to the administration of justice and legal services. So we look at the performance of our officials in this area. The Secretary also mentioned the 8 areas of work, and we will be discussing those items. Without further ado, I give the floor to Ms. Esther Leung from the Judiciary. Ms. Leung, can you try to stay within 10 minutes? Thank you. Thank you. We have submitted some slides, and I will go through the key points. The independence of the judiciary is enshrined in the Basic Law. We got Articles 2, 19, and 85. Those articles highlight that the judiciary exercises judicial power and has the power of final adjudication free from any interference. Judicial officers in exercising judicial power will not be held legally liable for the performance of judicial functions. Article 88 of the Basic Law states that all judges of the courts of the HKSAR are appointed by the Chief Executive on the recommendation of an independent commission. Every judicial appointment under Article 92 is based on the personal and professional qualities of the candidates. We can also recruit officers from other common law jurisdictions. Article 104 of the Basic Law states that when assuming office, all judges and judicial officers have to swear an oath to say that they swear allegiance to the HKSAR of the People's Republic of China. So our job as the judiciary is to maintain judicial independence and the highest professional standards, to uphold the rule of law, which safeguard the rights and freedoms of the individual and command confidence within and outside Hong Kong. At the apex of the judiciary, we have the Chief Justice, and this is in line with the Hong Kong Court of Final Appeal Ordinance. The Chief Justice is the head of the judiciary and runs the judiciary and performs other functions as may be lawfully conferred on him. All judges and judicial officers have to take the judicial oath when assuming office. The spirit is to uphold the rule of law, to put the public interest first, upholding the Basic Law, acting with integrity and administering justice without fear or favor, doing justice and serving the HKSAR. Now, the organizational structure of the judiciary. So, at the top, we have the Chief Justice of the Court of Final Appeal, and then under him, there are 2 divisions. First, you have the court leaders, and the judges at various levels of court. These are the people exercising the judicial power. And then on the other side, you have, meaning in the other division, we have the judicial administration under me as the judiciary administrator. So both divisions are responsible to the Chief Justice. The judiciary consists of courts and tribunals at various levels. At the top, there's the CFA. Below that, we have the High Court, made up of the Court of Appeal and the Court of First Instance. There's also the Competition Tribunal, presided over by a High Court judge. In the middle, you have the District Court or equivalent. By equivalent, we mean the Family Court and the Lands Tribunal. Further down the hierarchy, we have the Magistrates Court or equivalent, and that includes the Juvenile Court, Coroner's Court, the Labor Tribunal, the Small Claims Tribunal, and the Obscene Articles Tribunal. Now, our key areas of work. I will discuss judicial appointments, court operations, wider use of technology in court operations, and enhancement of court facilities. These are the areas close to the heart of previous terms of LegCo. On judicial appointments, in recent years, we have been active in open recruitment to fill up the vacancies in our judicial officers. We have made 25 judicial appointments since our recruitment started in 2023, and the appointments cover judges of the CFI, the District Court, the Lands Tribunal, and the magistracies. The latest round of recruitment started this month. Recruitment for other levels of court will also start later this year. Apart from appointing judges on permanent terms, we will also appoint deputy judges and recorders to meet our operational needs. In recent years, we have also worked with the legal profession to hold career talks and seminars. That's to encourage legal professionals to learn about the work of judicial officers. We also improved the conditions of service of judges and judicial officers. So we enacted a law to extend the retirement age. Those are measures for us to retain existing judges and hire new JJOs, meaning judges and judicial officers. Now, some highlights of court operations. And we have to meet this growing workload. In 2024, our caseload was 552,000, up 9% from the past 5 years. We disposed of more cases than the average of the previous 5 years. For most civil cases, the waiting time met our target. In contrast, criminal cases are more complicated with longer trials. So for the CFI and the District Court, the average waiting time for criminal cases remained on the high side. The average waiting time for criminal cases has, however, seen gradual improvement. Other challenges include complex civil and criminal proceedings, and also we still see an influx of leave applications for judicial review on non-refoulement claims. Now, for the complex civil and criminal proceedings, as you can see from the table, those proceedings come from the Anti-Extradition Bill Amendment incident and also the national security-related cases. So 90% of those cases are the Anti-Extradition Bill related. For national security cases, that's at 88%. I'm talking about disposal rate. The remaining cases will be scheduled for trial this year, and once those cases are gone, the impact on other proceedings will subside gradually. Another challenge in recent years is the leave applications for judicial review on non-refoulement claims. So we hired more retired judges to serve as deputy judges of the High Court to deal with these applications. But these judges have other cases to deal with as well. That's why last year we launched a special scheme. We appointed eligible private legal practitioners to serve as dedicated officers dealing with non-refoulement claims. We also streamlined administrative procedures and the delivery of judgment. By the end of last year, we saw impressive results. We used to be able to deal with 2,500 cases per year, but by the end of last year, we dealt with more than 3,700 cases. At this rate, if we can get more people to serve as deputy judges, we will be able to deal with and clear the backlog in a few years' time. We uphold justice and judicial independence. On that basis, we will deploy long-term and short-term judicial resources. We will improve case management. We will make greater use of technology and also enhance court facilities. We will take this multi-pronged approach to meet the challenges. We also promote the use of mediation in court proceedings. Mediation is a main option in alternative dispute resolution. We adopted new measures where we referred cases to mediation. More than half of those cases ended in partial or full settlement. On technology, there are a few flagship measures. First, the Integrated Court Case Management System, or the ICMS. You can see a timeline here. Back in 2020, we enacted the ordinance. Starting from 2022, the system was adopted in phases. It started with the district court, and then other courts adopted the system. Court papers and documents and also payments were processed on this platform. By the end of 2024, the system was adopted by certain bulk claims of the Small Claims Tribunal. And then last year, the system was extended to the civil proceedings of the High Court. Our plan is to have the CFA and also the criminal cases of the High Court, as well as the non-summons court of the Magistrates Court and the non-bulk claim cases of the Small Claims Tribunal adopt the system. Starting from the second half of this year, for legally represented litigants, they will have to use the ICMS to file documents. We also make use of e-bundles. Between 2020 and 2025, more than 2,000 hearings adopted e-bundles. We also adopt remote hearings. Early last year, LegCo enacted the Court's Remote Hearing Ordinance. From that point onward, we started promoting remote hearings. Starting early this year, for non-trial criminal proceedings, such as bail proceedings, we have adopted remote hearings. We also do live casting of court proceedings outside court premises. Starting from April last year, we launched a 2-year pilot scheme. For suitable cases, meaning all substantive appellate proceedings, we started offering live casting so that people outside the court premises can watch the proceedings in real time. After the proceedings, the videos are kept for a month on the website for people to access. This pilot scheme will conclude in 2027, and then we will review the scheme. Now, we also use voice-to-text technology. This is an AI-powered technology. Starting from 2024, we adopted this voice-to-text technology. Last year, we also trialed the use of such systems to produce transcripts. We will keep reviewing the scheme to see if we can expand the scope of the use.
Moving on to the use of AI in courts, in 2024, we promulgated the first set of guidelines on the use of generative AI for JJOs and support staff. We advocate the approach of using AI in a responsible manner. In addition, except core judicial work, we use AI appropriately, and we are laying the groundwork for developing new guidelines on the use of generative AI for the legal profession and other court users. We will consult the legal sector later on. On the use of technology, we need to improve our IT infrastructure. The new district court building is under construction on Caroline Hill Road. We have already secured funding from the council, and we are doing the preparatory work. We uphold the highest level of standards of the government in order to ensure stability of the systems. Regarding the enhancement of court facilities, 2 projects are underway. Regarding the new High Court building, we have reserved the sites of the existing Queensway government offices and High Court building for the project. We have started work in the initial stage with the relevant government department. Next, on the construction of new district court building, the ASD told us that the works will be completed in the second quarter of 2027. After tests, we expect the commissioning of the new district court building in the second quarter of 2028. Last of all, I'd like to talk about the Wangfuk Court fire in Tai Po. We aim to provide better support to the affected residents in Wangfuk Court. We want to expedite the handling of all legal proceedings in relation to the Wangfuk Court fire. A dedicated task group led by the Chief Judge of the High Court has already drawn up initial principles and guidelines on priority handling of legal proceedings. A designated team of support staff is processing probate-related matters concerning the deceased of the incident. A hotline has been set up to provide assistance. Relevant information will be disseminated with the 1 social worker per household arrangement. Probate-related scheduled fees for deceased victims will be waived. Coroner-related matters have also been accorded with priority. In other words, we strive to expedite the handling of all matters and proceedings in relation to the blaze in the Wangfuk Court. We look forward to more discussions on the relevant matters with members in the coming year. Just now, the document is CB-325/2026-02. Before I give the floor to the LED, I'd like to say once again, as Director Xia Baolong said, that the Judiciary operates without any interference, not just the legislature and the executive. The Central People's Government attaches importance to the fact that the Judiciary of Hong Kong operates without any interference. I'd also like to take this opportunity to congratulate on the assumption of duties of Mr. C.M. Chen, Director of Legal Aid. Whenever you're ready, Mr. Chen. Thank you. I'd like to once again thank the government for its trust to appoint me as the Director of the Legal Aid Department. It's been just about 4 weeks since I took up the duty as the Director of Legal Aid since the 2nd of January. I thank different individuals, including members, for the valuable opinions on the legal aid service in Hong Kong, especially with regard to outsourcing civil and criminal cases, guarding against the abuse of legal aid, as well as non-refoulement claim cases. A lot of views have been expressed I will continue to maintain good communication with members and the public. We have a very well-established legal aid principles. It is the cornerstone of the rule of law in Hong Kong. It makes sure no one who has reasonable grounds for pursuing or defending legal action in the courts of Hong Kong is denied access to justice because of lack of means. Since October 2021, the CS Office and the Legal Aid Department reported the work of the legal aid to the Council. We touched upon cases, the enhancement of transparency, the enhancement of case management, and so on. In 2023 May, in 2025 July, the Legal Aid Department reported the work of the department to the Council. In a moment, I will give the floor to Ms. Juliana Chan to take members through the work of the department. Afterwards, we will take members through the highlights of the work this year. And I'll give the floor to Ms. Chan, Deputy Director. Good morning, everyone. First of all, I will talk about the services of the Legal Aid Department. On the caseload, criminal cases 8,000 odd, civil cases 8,000 odd, and criminal cases 4,000 odd. About 50% of the cases have been granted legal aid. And we will approve the cases rigorously, and we will also ensure that resources are used well. We render assistance to members of the public who run into difficulties on their day-to-day matters. There are two tests. One, means test. We ensure only those meeting the financial eligibility test will be granted legal aid. There are two main factors at play. The financial eligibility limits cover both the disposable income and capital of an applicant. What could be exempted? For the units in which the applicant lives, this could be exempted. There is also a statutory waiver taking into account the living expenses of the family members. Take a 3-person household as an example. The exemption amount is about $10,000 or so. For a 4-person household, the amount will increase to $20,000. For criminal cases, the means test stays the same, save and except one criterion. Despite exceeding the limits, an applicant may still receive legal aid if the director is satisfied that it is desirable in the interest of justice to grant legal aid. Only applicants who can show reasonable grounds for taking or defending proceedings will receive legal aid. The responsibility of the legal aid is to ensure the reasonable use of public funds. In other words, an applicant must show that they have meritorious grounds for a case. In some cases, even if an applicant has a reasonable ground or argument, however, if only a trivial advantage will be gained even if the case is successful, in these cases we consider the use of public funds not reasonable. That applicant may not be granted legal aid. Regarding criminal cases, we have the presumption of innocence operating in Hong Kong. So for trial hearings, legal aid will usually be granted. For appeal cases, it's a little bit different. There must be meritorious grounds of appeal before legal aid will be granted for criminal appeals. A lot of civil cases relate to people's livelihood. Two major types of applications: personal injuries claims in family and matrimonial cases, with the former including traffic accidents and employees' compensation, For PI claims, they account for 41%, and for family or matrimonial cases, they account for about 34%. Civil cases are less likely to be granted legal aid. There's a major scope of services when it comes to civil proceedings. Basically, those proceedings in the district court and above, certain coroner's inquests, these will be covered. For defamation cases, legal aid will not be granted. We have a supplementary legal aid scheme targeting the sandwich class. It is a scheme with good reputation. We aim to help the middle class. The figure stands at $449,000 for the means test of the middle class. And one can apply for the supplementary legal aid scheme. It is different in the sense that it operates on a self-financing basis. It is funded by contributions paid by the aided parties. PI cases, employees' compensation claim, representation for employees in appeals, these will be covered. And there will also be cases covering certain professional negligence claims, such as the dentists. Representations for employees in appeals against awards made by the Labor Tribunal will also be covered. There is a misunderstanding that civil legal aid is free, but that is not the case. Applicants need to make a contribution on a sliding scale according to their assessed financial resources. The vast majority of applicants do not have to pay at all, but for the middle class, for instance, they will have to pay about $100,000 or so. As for CSSA recipients, they do not have to pay. Reimbursement of the costs incurred by the LAD for the aided person out of the property recovered or preserved if the case is successful. That is the director's first charge. This will usually be waived. For example, monthly maintenance for children and part of the monthly maintenance for spouse may be exempted. There is one special occasion. If the director considers that it would cause serious hardship to the aided person, the director has the discretion to exempt part of the amounts. As for criminal cases, they cover proceedings in magistrate's court, criminal proceedings at district court and above. Committal proceedings in the magistrate's courts will also be covered. As for criminal committal proceedings and other trial cases, about 99% of these applications are approved. As for appeal cases, it's a little bit different. Applicants will have to advance meritorious grounds, hence the lower percentage. The legal aid applicant or aided person can appeal to the registrar of the High Court in case the application is rejected. The ordinance provides that the decision of the registrar of the High Court is final. If the application is related to appeal to the Court of Final Appeal, there will be a committee of review, which is chaired by the registrar of the High Court and a representative from the two professional legal bodies in Hong Kong. Regarding criminal cases, there is no, so to speak, an appeal mechanism, but there will be an expedited mechanism to handle the applications. Well, Deputy Director, probably you can go faster, you can simplify the procedures, or you can move on to the next topic on the work of 2026.
So we will continue to do our work in case assignment and guarding against abuse. On case assignment for civil cases, the aided person will have their cases dealt with by private practitioners. So the aided person can nominate lawyers, but the director will exercise discretion on whether to assign the lawyer nominated. In criminal cases, the director always assigns the lawyers. Now, here's the limit on the cases assigned. For details, members can refer to the slides. Now, over to the director of legal aid. Please stay within the time limit. 6 members are waiting to speak, and I will give each member 4 minutes, so I will be brief. So I will briefly go through the major areas of work for the Legal Aid Department. Every year, we review the ordinary legal aid and the assistance scheme in terms of their amount. So we look at the composite consumer price index C, basically inflation. Now it stands at $400,000 or so. We adjust the rate every year. On criminal legal aid, we also have a mechanism. This mechanism is adjusted every 2 years based on consumer price index C. This year, criminal aid is due for review. On paying brief-out lawyers, this is a topic top of mind for the legal profession. The Legal Aid Department has taken measures to pay those lawyers sooner. Over the past few weeks, I've met with people from the Law Society, the Bar Association, and legal members. The Legal Aid Department will prepare frequently asked questions for those legal professionals' bodies to refer to. Now, on publicity, public education is important. So I will keep up the effort to share information on the LAD's website and social media. The Legal Aid Council also shares information on legal aid on its website. We will continue to work with NGOs, schools, to hold talks. We will tell the public about how legal aid works, to tell our story well. Now for the fire at Wang Fuk Court in Taipo, the government attaches importance to the legal aid applications related to the incident. Those applications have to do with claims for compensation, etc. We have received 354 applications for legal aid so far, and we are dealing with those applications at full speed. We deal with every application the moment it is received, and the LAD has reached out to those applicants for follow-up to help the affected residents learn about the LAD services. Starting from today, at 7 locations, there will be counters where officers from the Legal Aid Department will explain the legal aid service to applicants, and we will start this afternoon. They are in Loxin Estate, Good House, Trackside Villas, Lockwo, Tongyu, and the Lutheran Church's residents, and also a couple of other residences. Wang Fuk Court residents can also sign up online for these counters. The LAD will take a compassionate, practical, and lawful approach within the existing framework to give swift access to legal aid to the affected residents. We have set up a dedicated task force to offer appropriate support to those residents. I know we're almost out of time, but I want to go into some specifics about the measures we have come up with. First, a dedicated helpline to address inquiries from the type of residents. We answer questions, we provide assistance. Second, we have streamlined the application procedure, and we have waived some requirements about information. We will reach out to banks and insurers for information instead, so the affected residents won't have to provide all that information themselves for the means test. We will also exempt, or rather disregard, the donations and assistance for those residents when we proceed with the means test. For applicants aged 60 or above, we will also the limit on the ordinary legal aid scheme at $449,600 when we process their means test. When we grant legal aid, we also send appropriate legal representatives to deal with the litigation as soon as we can. That's to ensure those people have access to timely support. Thank you. And now open the floor for members. Please limit yourself to 2 questions and please observe the time limit of 4 minutes for each member. This is just a policy briefing today. There will be time for you to discuss matters of concern to you in our future meetings. So here's the order. Professor Priscilla Leung, Ms. Maggie Chen, Dr. Thomas So, Mr. Nicholas Chen, Mr. Wu Yingpeng, and Dr. Junius Ho. Professor Leung. 2 comments and 1 question. I think we can do away with declarations of interest. Otherwise, I will have many things to declare because I have many students. We're talking about public policy here, so I will not declare my interest or cooperation, etc. The judiciary has told us we have dealt with 97% of the cases from the 2019 social unrest. But we also need to get the following up work right. Young people are involved in these cases. What happens when the cases are settled or when these people are released from prison? So the judiciary should proceed with cross-departmental follow-up actions. Second, I commend the work of the Legal Aid Department, and also congratulations to the new Director of Legal Aid on being appointed. We have been raising the issue of legal aid abuse for years. Finally, there's now a limit on the cases assigned to lawyers, and also the requirement about disclosing sources of finance. Tightening up the rules is the right way to go. This can remove the stigma associated with legal aid. As the new director knows, we have been raising the issue of excessive judicial review over the years, so I commend the work of the LAD. For the fire at Wangford Court, we're happy with the work being done by the LAD and the judiciary for their approach informed by reason, compassion, and legality. And also want to commend the good work done by the Department of Justice in terms of international legal cooperation. I want to discuss IOMAT in particular. There are claims in the community that this order has retrospective effect and we are trying to make up for a slip-up in the past, and I'm grateful to the Secretary for Justice for his opening remarks. This is not about retrospective effect. This has to do with Annex 3 to the Basic Law. It's an international convention. We are discharging our obligation as part of our country. This order is very clear. We respect the common law tradition of Hong Kong. That's why Hong Kong needs a piece of subsidiary legislation to give effect to the convention. Maybe the Secretary for Justice can tell us more about this. There are references to state members and immunities. The language is in the order. Look at the UN headquarters in New York. You need privileges and immunities for the representatives sitting at international bodies. With a clear explanation from the Secretary for Justice, there should be little room for misunderstanding among the public. But maybe I can get the Secretary for Justice to explain what that's meant by an international legal person so that we won't get any speculation or doubt about this? Secretary. Can we give the Secretary more time, please? Now, what do we mean by an international legal person? When we say a person in the ordinary sense, we are talking about human beings. But a legal person is an entity we treat as if it were a person. Take a limited company. A limited company has capacity, it can enter into a contract, and that's a legal person. And now we're extending this concept of a legal person to an international organization. The Convention on ILMAT is clear on this. Article 6, it's a schedule. Here it says that ILMAT can do a few things. It can enter into a contract. ILMAT can also obtain or dispose of land and other forms of property. ILMAT can start proceedings. It can be a plaintiff or a defendant. So you treat ILMAT as if it were a person, and this also applies to other international institutions. So we also give the same status to ILMAT. For example, ILMAT will need to open a bank account, otherwise it will run into difficulties with something as basic as account opening. Ms. Maggie Chan. I have a few points to make. We have the Secretary for Justice and his team here on nurturing talent, developing our institutions, and overseas promotion. I have seen rapid progress and a blueprint from the DOJ. I can see the passion in the work done by the DOJ, so I commend the efforts of the Department of Justice. Of course, the Judiciary and the Legal Aid Department are also doing solid work. So now I move on to my next point. It's about the Northern Metropolis. There will be dedicated legislation. I proposed this idea to the chief executive, and he accepted this idea. On data security and the flow of capital, the Development Bureau said they will discuss the matter with the DOJ. So now we have this proposal about dedicated legislation. We also have to consider how we incorporate the option to adopt Hong Kong law and adopt Hong Kong as the seat for arbitration within that legislation for the NM. And I hope the DOJ can also think about ways to help small and medium law firms in its blueprint. Now, I can see part of the blueprint covers emerging markets. I hope there can be measures to support emerging industries such as fintech, data science, biotech. These are the kinds of laws that the loop will need. Now I turn to my question. Congratulations to the new Director of Legal Aid. Legal aid does not cover building management. Can we create this new category to support minority building owners when they have to resolve civil disputes with owners' corporations or building contractors? My next question is for the judiciary. When we recruit judicial officers and judges, can we have a two-tiered pay structure for judges and judicial officers? Can we have a two-tiered system in the pay so that we can recruit talent?
Who will take the first question? SJ? legal aid department, and then the judiciary. Well, just now Ms. Maggie Chen gave us some views. I thank Ms. Maggie Chen for her views. We will do more work on some dedicated areas. Regarding dedicated legislation for the Northern Metropolis, we'll definitely follow up on these matters. Mr. Chan, indeed, under the existing mechanism, we don't give legal opinion to applicants. But a litigation element needs to be present in the application. Deputy Director. Well, excuse me, Madam Chair, I'd like to clarify. I mean, when minority owners sue property management companies, what about these cases? We need to support minority owners. As for personal reasons, I mean, if the cases are heard in the district court, then applications will be covered. What about building management? If one is being bitten by a dog, then it would not be covered. Well, I mean, minority owners what about for the resolution of general meetings covering common areas? Well, again, if the dispute is heard at the district court level or above the district court level, then the proceedings will be covered. However, if the cases are heard at the tribunal level, then these applications will not be granted. Well, first of all, they don't offer legal advice, and if the cases are heard in the district court level or above, then the case will be covered. Judiciary. There is a pay scale for JJOs, and this is not decided by the judiciary. Much like the civil service pay, there is a set of procedures and mechanisms. The government consults a committee, that is the PTSC, and then decisions will be made based on the judges in the Court of Appeal and in the CFI. They receive different pay to reflect their differences in the functions. As for the paid level for different JJOs, in some ranks, there is actually more than one tier. Dr. Thomas So. Thank you. First of all, I thank SJJA and the Director of the Legal Aid for the introduction. The walkthrough is very rich in content. I have two comments to make. One, just now the SJ talked about fostering legal cooperation with the GBA. I want to ask the heads of some mediation organizations to hold seminars in Hong Kong. However, sometimes the heads of these organizations couldn't get a visa or a permit to come to Hong Kong. They said an approval will have to be made. I asked the CMAB and they said, well, it actually wasn't under the purview. They asked me to bring it up to you. That's why I'm doing so now. Sometimes we had no choice but to hold the seminars in Shenzhen because they couldn't get a permit or a visa, but that is not ideal. We do want to ask them to come to Hong Kong. We want to foster exchange. So can the SJ help us in this regard? Can you relay this message to the higher-ups? Can a special approval be allowed? When it comes to seminars or exchange sessions on dispute resolution conducted with the GBA, can approval be made? My second question for the judiciary. There is public concern over judicial efficiency from the perspective of users. How long do they have to wait until the close of a case? First, you start a case, you make an application, the case is heard, and then how long does one need to wait before the final decision is made? Sometimes one has to wait for a whole year or even more than a year for the decision of the court. I'm glad to see some initiatives implemented by the judiciary. I'm also glad to see the use of technologies to shorten the wait and the overall waiting time for cases. I have two questions. Can the judiciary announce or disclose the data in relation to judicial efficiency? We want to draw comparisons. We want to compare the current data with data in the past. How long does it take to hear a case? I believe these data are open data. Is it possible to disclose these data? We want to better gauge the effectiveness of some policies. Next, moving on to case management initiatives. I'm not sure if the courts have any internal guidelines. That is, how long after the close of a case will a decision need to be made? On the use of technology, just now you said that AI at present isn't reliable, so it couldn't be used on some judicial aspects. Well, as AI is developing every day, will the judiciary follow up on the developments of AI? When one day you find it acceptable, AI could be used to help JJOs to expedite the handling of cases, as that is oftentimes the most difficult part. SJ, thank you. First of all, we work together with other policy bureaus. Whatever is good for Hong Kong, definitely we do our level best to do so. I will relay your view to the mainland units. In the Chinese mainland, they have their own standards, they have their own rules. Even if we express our concerns, we have to respect the internal arrangements of the Chinese mainland. We share a common goal. We want the best for Hong Kong and for our country. Before I give the floor to the JA, 3 members are waiting to speak, and Professor Leung has requested to speak again. If the administration doesn't mind, I will extend the meeting by 15 minutes. SJ, well, of course. Thank you. JA, thank you. Thank you, Dr. Thomas So, for the question. Regarding judicial efficiency, it is a topic we attach a lot of importance to. We have data on the waiting times of cases. We monitor these indicators. Every year in the annual report of the Judiciary, it details the overview of the waiting times and the target times for handling different cases. All these are published in our annual report. In the AJLSP, there are documents detailing the waiting times of different cases. There are also definitions as well as the factors at play in the past year. In which area have we seen improvements? In which area do we need to improve? All these are covered by our information papers. A few years ago, the Judiciary issued a practical direction It sets out the rules about the time that a JJO needs to pass down the judgment. If I remember correctly, they are PDs 36 and 37. Some JJOs apply for an extension to their respective court leaders. This information can be published to members. On the use of AI, we published the first set of guidelines in 2024, and we will keep a close eye on the developments of AI. When the time is ripe, without compromising judicial justice, we will allow JJOs to use AI in an appropriate manner. But we must remember these are tools. They cannot replace the independent judgment and the principal responsibility of a JJO. We'll continue to keep a close eye on the situation. Members expressed concerns over similar matters last week. Next, Mr. Nick Chan. I have a comment and I have 3 questions. Under the constitutional order, our judicial independence is confirmed, but we adopt an executive-led approach. I have a suggestion. Is it possible to invite the Chief Justice in Hong Kong to share with us on the HLSP? My next question is for the JA. The long waiting time of cases is indeed an issue. Some companies and enterprises consider coming to Hong Kong and boosting our local development, but time is a concern. We need to make good use of technology to enhance speed and efficiency. Next question for JA. The hourly rate of solicitors was last updated in 2018. It's been about 8 years. Any update? What do we think? How can we recruit more JJOs? My next question is for the LED. First of all, congratulations on assuming office, Mr. Chan. What about the payment to briefed out counsel? They have to wait for a long time before they receive the payment. How are you going to work on it? My third question is for the SJ. Promotion is difficult. There are fewer posts than talent. Do we practice outcome-related fees? Will we consider cross-section? Some people aren't really lawyers in Hong Kong, but they have accepted a brief. Then they provide legal services in Hong Kong, especially when it comes to corporate finance, financing, and so on. What do you make of it? Under the 15th Five-Year Plan, we already have the recommendations, but we want more to be done for Hong Kong in March. In the Chinese mainland, there is no foreign-related law matter. Can the contracts to be handled in Hong Kong when it comes to mediation arbitration? Thank you.
So I'll give 1 minute to the Judiciary Administrator and 1 minute to the Secretary for Justice. Let's start with the Judiciary Administrator. Thank you. As I said in my opening remarks, the definition varies for the waiting time in civil and criminal cases. So even before the trial, the clock starts in a criminal case. So even in other common law jurisdictions, the waiting time for criminal cases is always longer. Whereas for civil case, you get the preparations done and then you start scheduling a case, so the waiting time for civil cases will be shorter. For civil cases, the waiting time is on target in most cases. Now, for cases involving longer proceedings, we still have to work on them. We have to find more qualified judges, and that will improve the position, and we will keep an eye on this problem. On the hourly rates for solicitors, this is a rather complicated issue. There's a mechanism in place to deal with that. In 2018, we conducted a review. And then every 4 years, we look at the Composite Consumer Price Index as a starting point to update the rate. For 2025 to 26, we're in the second cycle for this update. The Judiciary is reviewing the rate. Once we have a conclusion, we will make it available to the legal profession. I have to draw a line here because we're supposed to end the meeting here, but I'm extending the time. Now over to the Director of Legal Aid. I thank Mr. Nick Chen for his questions. When brief-out lawyers complete cases for aided persons, the LAD is supposed to pay the solicitors. But we have to bear in mind that legal aid involves public money, so we have to be the gatekeepers here. We have to assess whether the fees make sense. That's why we have to go through a procedure. We have to discuss the fees with the brief-out lawyers. That's why, as I said in my opening remarks, I got in touch with the Law Society and the Bar Association. We have been looking for ways to speed up this discussion about assessing the fees so that the brief-out lawyers can get their payment as soon as possible. Over to the Secretary for Justice. I thank Mr. Nick Chen for his questions about opportunities for the legal profession. I cannot go into the specifics because we don't have the time then, and I don't have the information at hand. I do have some ideas. First, I will be listening to the industry's views attentively. I want to get the views and the arguments for those views from me. I want to make sure that the ideas are in line with our public interest and that's consistent with our rule of law. And I keep an open mind to all such ideas that are consistent with these principles. On other people taking away our business, we follow the law. That we have the legal practitioners ordinance. There are laws and rules on practice. Of course, when there's a breach, we will follow up on those cases seriously. And when enhancements to the law are needed, we will approach such matters with caution. The overarching principle is to make sure everything is in the overall public interest of Hong Kong. Next, Mr. Wu Yingpeng. Thank you, Madam Chair. I thank the officials for their presentation. I have some questions about IOMED. IOMED is an example where our country takes part in global governance, and IOMED will be a key platform in so many ways. This is also an institution where we can promote this idea of a shared future for humanity. Given the way geopolitics is, the US and the rest of the West will not want to see IOMED succeed. They will try to undermine IOMED. They may sanction the people working at IOMED. Last February, the US president signed an executive order sanctioning the officials at the International Criminal Court. The US president also dismissed the ICC as unlawful. That's because the ICC took actions against Israel, a U.S. ally. And then further sanctions were imposed on ICC judges. So for us, when we legislate for IOMED, and especially when it comes to privileges and immunities for IOMED officials, do we have contingency plans for possible foreign sanctions on the people at IOMED? Thank you. Secretary for Justice. I thank Mr. Wu for raising this concern. We will be watching this closely. I mentioned an order just then. That order grants privileges and immunities to the people working at IOMED, so we cannot just charge someone at IOMED. Now, any extra territorial sanction is not recognized in Hong Kong. We only recognize sanctions that are consistent with the UN regulations, international law, and international norms. So when a foreign country tries to impose so-called sanctions on people in Hong Kong, if that sanction is against international law, we do not recognize such sanctions. I think the Secretary has made the position clear. Can we write that into the law? Secretary, any response? This principle is clear, and the regulations are clear. And that should be enough to address Mr. Wu's concern. Ms. Christine Fong also pressed the button when I drew the line, so please be succinct when you speak. You will be able to put your questions. Thank you. I thank our officials for their contribution to our rule of law. On the asset limit for legal aid, in civil legal aid, the upper limit is $449,000, aside from a self-occupied property. Can we adjust this limit for civil dispute in the community? Director of Legal Aid. Ms. Fong wasn't here when I delivered my opening remarks. Just then I said that we would look at the consumer price index and then propose an increase to the limit this year. So how high will that limit go this year? How will we adjust that? We will have to look at the CPIC before we can arrive at the specific level, and then I will update LegCo accordingly. Deputy Director of Legal Aid. Anything to add? No? Professor Priscilla Leung, 2 minutes. Thank you, Madam Chair. IOMED is about mediation between parties so that we can achieve a win-win outcome. It's an honor for Hong Kong to be hosting the headquarters of IOMED. So I support the subsidiary legislation. The order will protect the rights of the personnel from the state members of the IOMED Convention. This is perfectly in line with international standards. And we should work towards becoming the headquarters not just of IOMED but also of the United Nations. Judges hear national security cases, and then some people may deliberately impose sanctions on our judges. We have huge respect for our Secretary for Justice. I believe we will all stick to our posts in upholding the rule of law. Now, I don't need an answer right away. I know time is limited. But my question is, for those performing their duties and because of that they face unjustified sanctions, we refuse to recognize such sanctions. We need a better mechanism to protect these people facing sanctions for performing their duties. We have to show them communities level solidarity. I'm confident that our judges will not be daunted by such unjustified threat, but we should explore a mechanism to protect judges. I agree too. Secretary, anything to add from you? I acknowledge the concern. I'm one of the victims of sanctions, but I go about my life as usual. This is a national security issue. So some matters are not suitable for public discussions or analyses. The central authorities have said time and again that we will have appropriate responses to ensure confidence in the duties that we will perform. Just one remark. For these people performing their official duties, we support them and we think they deserve better protection. That's my point. Every member has got a chance to speak. I'm grateful to the 17 officials who joined us for the policy briefing. We will hold a work meeting next week, and then we will work out the items for discussion for our future meetings. Next item, any other business? There is no other business. I adjourn the meeting here. Thank you.